Chief Justice, may it please the court.
I'm Amy Swearer.
And I'm GianCarlo Canaparo.
And welcome to SCOTUS 101, where we break down what's happening at the Supreme Court, what the justices are up to,
and other things related to our favorite branch of government. Welcome to another episode of SCOTUS 101.
Welcome, welcome, welcome.
We have another roller coaster of a week for the Supreme Court opinions. 2 weeks ago, you might recall we had no cases. Last week, we got 5 all on one day. And this week, we once again have 1.
Yeah, honestly, these last weeks have reminded me of a particular ride at Busch Gardens, Williamsburg. I'm not going to tell you which one it is in case you haven't ridden it before. But in the middle of this ride, you're going on your merry way, and then they stop you in a dark tunnel. And you're just like, why are we not moving? Is the ride broken? I broke it. I broke the ride. And then out of nowhere, the floor opens up underneath you. It drops you like half a story, and then they shoot you out into the rest of the ride. And I feel like that's what SCOTUS has been this month. We were on our merry way, the floodgates had opened, and now we're just sort of stuck in a tunnel. But we know those floorboards any day now are going to open, and this is going to be an insane end to the term. I think at this point, GC, if I did the math right, in order to get done by the end of the month, we're at like 8 opinions a week, something like that.
Yeah, that sounds right. I would be so surprised if the term did not get extended. But in the meantime, don't worry, we're still doing better than ESPN. We have a lot of SCOTUS news to talk about and an interview you won't want to miss.
I love that we're still bashing on ESPN here.
Well, up it's first in the news. Current Solicitor General Noel Francisco is expected, or rumored, to step down soon. It's not unexpected. This is the summer of the last year of the president's first term. It's a pretty common time for long-standing officials to move on. We'll be very excited to see what Noel does next. His replacement, at least temporarily, will probably be his principal deputy, Jeff Wall. But there's a rumor that Patrick Philbin, who is presently Deputy White House Counsel, might be under consideration for the post. So we'll see.
Yeah, both of those guys are extremely smart, talented advocates. We'll keep you updated as we learn more. I know that the nature of being Solicitor General is that you argue a lot of cases in front of the Supreme Court. That's sort of just how it goes. But it has certainly seemed like Noel Francisco has been all over so many high-profile cases over the last 3 years. I mean, you think about it, even just from a couple weeks ago, you had the tax return cases. Before that, the census case, the redistricting case, agency deference in Kaiser v. Wilkie, the scandalous trademarks case. He was involved in Masterpiece Cake Shop, where he had oral argument in that. So he's just been all over the place, and it's sort of like this turning point of what are we going to do without Noel Francisco arguing? What is life now?
Well, I don't know, but we'll find out. I'm really curious to see where he goes next, whether private practice or, who knows. Next up, though, we have opinions, or I should say opinion, in Lomax. Now, Lomax, you've probably heard about it because it is a very exciting case to nobody at all, except me. I might be the only person.
Me too. Throw me on the excitement bandwagon.
Okay, excellent. That's 2 of us, and probably the litigants, but I'm not sure about that. The issue in Lomax is whether the prisoner pleading 3 strikes rule applies to dismissals without prejudice. What's the prisoner pleading 3 strikes rule? Well, I am delighted to tell you it is a rule found in 28 U.S.C. 1915G that says a prisoner may not file any civil lawsuits in forma pauperis, that is, free from having to pay filing fees, if on 3 or more prior occasions while incarcerated he has filed an action that was dismissed on the grounds that, quote, it failed to state a claim upon which relief may be granted. The circuit split about whether a dismissal without prejudice counted as a strike. The Supreme Court, in a unanimous opinion by Kagan, held that, and this is correct in my view, that the plain text of the statute makes any dismissal with or without prejudice a strike. Now, Lomax might seem esoteric and not one that most people interact with on a daily basis, but I have a theory that Lomax actually has pretty broad implications for how district courts handle successive pleadings, not just in this context, but more generally. And so if you would like to learn more about the esoteric issues in Lomax, I wrote a piece in Law 360, which I'd be happy to send you.
And in case you forgot that COVID-19 is still a thing, it is, and we have some case updates. The Justice Department this week filed an amicus brief with the Ninth Circuit in support of a free speech challenge to California's COVID-19 related ban on, quote, in-person political protests, unquote. According to the DOJ, this brief is part of Attorney General Barr's April 27th initiative directing the review of state and local policies to ensure that civil liberties are protected during the COVID-19 epidemic. One of the petitioners in this case is a firearms instructor who had been seeking to hold a protest, I believe on the grounds of the California State Capitol building, part of his objection to the state's delays in processing background checks for gun purchasers. Another petitioner is a candidate for the U.S. House of Representatives who wanted to organize a protest related to some of California's COVID-19 restrictions. And so the DOJ, in its brief, brought up a couple main points. The first, and I think biggest point, is that the First Amendment means to the DOJ that even during pandemics, the state does not have carte blanche to ban peaceful public protests. And then very, very interesting to me was how they tied this in to the George Floyd protests that we've seen over the last week. The brief essentially said the real and legitimate national outcry over George Floyd's death has actually shown the importance of peaceful public protests to maintaining our civic fabric. Moreover, going forward, it could raise First Amendment concerns if California were to hold other protests, such as the ones desired by these petitioners, to a different standard than they held the George Floyd protests.
Yeah, this brings up an interesting point about church challenges too, where you have seemingly different standards applied to different activities, and at least there are hints of sort of political considerations going on behind the scenes. With these church challenges, you recall last week that the court rejected an emergency challenge brought by a church to California's COVID-19 order, which treated churches worse than it treated certain businesses. Last week, I discussed Robert's opinion. He provided the deciding vote, and I articulated what I thought he got wrong. The week after the court issued that opinion, various cities, towns, counties in California updated their COVID-19 orders, and prominent in some of them was a ban on gatherings of more than 10 or 12 people, unless it was a protest, in which case the orders allowed for 100 people. Now, this sort of disparate treatment between protests and churches, or one kind of protest or another kind of protest, strengthen these kinds of challenges to the orders, because they undermine the claim that these are advancing a health policy concern. Because as we know, COVID doesn't distinguish between a protest and a church service. So I would expect you might see more renewed challenges from churches in light of these orders that undermine the ostensible health policy considerations that are motivating these orders.
Yeah, this was certainly, just even in terms of police practice, a very interesting thing that you saw being brought up, for example, in New York City, where, you had protesters arrested for things like assaulting police officers or breaking curfew, but not for breaking COVID-19 restrictions, where, just down the road in certain Jewish communities, police were handing out fines, for kids being in parks. And so I think you saw not just even in explicit policies, but also in just some of the internal practices for how different types of similar gatherings were treated. This is going to be very, very interesting how this affects legal arguments going forward.
That is it for SCOTUS News for this week. But next up, I interview former federal judge and former Attorney General Michael Mukasey. Judge Mukasey, as he prefers to be called for reasons you'll learn shortly, has had an incredible legal career. He was an AUSA, a district judge in SDNY for 19 years, a law professor and attorney general, and now he still practices law at the firm Debevoise Plimpton. Well, I'm joined today by General Michael Mukasey. General Mukasey, thanks for joining us.
Thanks for having me.
So, General, settle a debate for us. On a previous episode of the podcast, my co-host Amy and I had a little debate about the proper title for an attorney or solicitor general. The common convention is to call them general, but I think that that's incorrect. general is the adjective in those titles. So what do you think?
Well, I have to tell you that being called general used to kind of disconcert me when I was in the office, and was the British Attorney General is referred to as attorney, which struck me as much more rational. The title general can be a little bit embarrassing, particularly when you're in the company of actual generals, and I used to kind of avoid it. Luckily, there were people who referred to me as judge, which is a lot more comfortable, and so we could avoid that problem.
Do you actually prefer being called judge or general, since you've got the luxury of both?
If the choice is between the two of them, I think I would prefer judge, although I recall arguing once before the Fourth Circuit, and they have a wonderful tradition of coming off the bench after the argument and shaking hands with the lawyers. It's a really lovely tradition. And one of the judges, as she passed, reached her hand out and said, "Is it judge or general?" I said, "Here it's Mister." That's actually either judge or Mister is fine.
I see. Well, I'm glad to see that you're on the side of reason when it comes to this general thing. It's very strange to me, but old traditions die hard. I'm on a losing side of a crusade here.
Me too.
So you had quite the career in the law. Did you know that the law was always going to be your calling?
Actually, I did not. In fact, when I was younger and thinking about what I was going to do, I thought I really wanted to be a journalist, a newspaper man. And I did that for a while. And it was kind of transitory and a little bit unsatisfying for that reason. And also, it occurred to me that if you write for newspapers or for television or radio, then you are in essence simply describing what other people do, and you're not acting on events yourself. And that there was a lot more opportunity to act on events if you were in the law than if you were simply writing about what other people did. So I chose a legal career.
So why the law rather than, say, business or something else where you're in the thick of things?
Well, I had no experience in business. Nobody in my family was involved in business in any meaningful sense, and I did have relatives who were lawyers. So, in fact, I worked as a messenger and as a fill-in librarian and so on for the law firm that one of them was at, and so I got a taste of it that way.
You've said in a previous interview that one of your regrets is not clerking. Can you tell me a little bit about that?
Sure. I think clerking gives an opportunity, first of all, of course, to develop a relationship with somebody who is actually a judge, and thereby give you an insight into what judging is all about. And secondly, just from a professional standpoint, it gives you a chance to watch a lot of other people make mistakes that you then don't have to go out and make yourself. And I didn't get that chance, and so I went out and made them myself. Which is a little bit more difficult way to learn the trade.
Well, I clerked and I made mistakes on the job, so I guess they're to be made wherever you are.
Right. In fact, sometimes the mistakes on the job can be more difficult and embarrassing than the mistakes off it. I know of one law clerk who clerked for Judge Edward Weinfeld, who was a legend in our courthouse in the Southern District of New York. And part of the legend was that he would always come out on the bench at precisely 10 a.m. as the clock in Foley Square was striking 10. He would come out on the bench. And one day he was poised in the roving room to come out on the bench, and his law clerk closed the door, and he heard the telltale click of the lock engaging. And the clerk didn't have a key.
Oh, no.
And the judge kept saying, I need to get out there. And of course, the clock started to strike. And eventually they did get the door open, but the judge was a couple of minutes late getting out on the bench for the first and only time in his career. And the poor law clerk never lived it down.
Oh, boy. So tell me, you were a judge 19 years. Is that correct?
Yes.
So tell me, how did you figure out what worked for you with your law clerks as you came into this for the first time?
Well, I decided that obviously law clerks and other people have strengths and weaknesses, and that rather than put them on cases on a random basis, that we would sit down when we got a bunch of motions and allocate them based on what people's strengths and weaknesses appeared to be. And then the law clerks would continue on that particular case for the duration. And that worked fairly well, rather than assigning by, odd number, even number.
Sure. Tell me a little bit about how you used your law clerks. Did you have them draft orders to begin with? Did you draft orders? Tell me a little bit about that division.
Well, it worked in a variety of ways. They would draft orders or opinions in relatively, in civil cases, largely. I did all the criminal stuff, at least the first draft myself. And I would draft some, and then we would exchange drafts and go over them and edit them and get them down to what I regarded as a passable final version. But nothing ever went out unless at least four eyes went on it, and often six.
So when you were a judge, how did you choose your clerks? What did you look for?
Well, usually by recommendation of people on faculties or lawyers. And to a certain extent, I let the admissions committees at what I regarded as better schools do my work for me. And I chose from when I was choosing simply based on resumes, I chose from a group of about half a dozen law schools. And but then I would also take recommendations from people who would call up and say that they had this or that person who they thought was particularly able. And often those people were, after the interviews, were given clerkships.
So if you were to give a law student who wanted to clerk a piece of advice to maximize his or her chances, what would you say?
Learn how to write. Learn how to write clearly, succinctly. I used to distribute to my clerks on the first day of their clerkship an essay called Politics in the English Language by George Orwell, which I think is the best and shortest guide to clear writing that I've ever encountered. And if they took that essay to heart, then they usually gave me the kind of product that I could use. It was a wonderful lesson in using simple words, not complex ones, and thinking truly about what it is you want to say rather than simply letting the words arrange themselves for you.
Now, I'd love to talk a little bit about your journey to the bench. Can you tell me about, did you know you always wanted to be a judge?
I decided after about 5 years of practice that I wanted to be a judge. And I know that it was about 5 years because during my interview for the U.S. Attorney's Office, which was about 5 years into my career, I was asked by Mike Seymour, the then U.S. Attorney, how if I could get my wish after 10 years, where would I be? And I said I would be a district judge. So I must have wanted to do it by then. But I found that when I went to court, I would watch the judge, and my reaction would be either I would, yes, I would do it that way, or no, I wouldn't do it that way. And so I found myself kind of figuring out how I would do that job if I ever did it, and eventually came to want to do it.
So how did you end up getting nominated?
Nominations to the district court are within the power and discretion largely of United States senators. Senators generally from the when they're from the same party as the president. Although in New York, the senators, because for a long time we had one senator from each party, worked out an arrangement whereby the senator from the party that controlled the White House got 3 picks, and to every one that the other senator got, and that was statewide. So the idea was to get yourself known to a United States senator and get that senator to know that you want to be a judge.
And how did you do that?
Well, there were 2 people who were close to then Senator D'Amato, and they both knew that I wanted to be a judge, and they both got the word to him, and eventually I got a call from his office saying that he was willing to submit my name.
Now, you actually managed something which in the modern era is pretty unprecedented, in that while you were on the bench, members of both political parties supported you. And in fact, Senator Schumer once put forward your name as a potential Supreme Court pick and later supported you in becoming the Attorney General. Can you speak a little bit to the bipartisan support that you earned and whether you think that's possible to cultivate in today's political climate?
Well, I tried. I mean, I don't know whether I earned it or not, but I tried to decide things on the merits and without a view toward who would approve and who wouldn't. But I have to tell you that the proffering of my name for the Supreme Court, I'm not sure was an exercise so much in bipartisanship, because at the context in which it occurred was that Justice, as he was initially, Justice Roberts, before he was nominated to be Chief Justice, he was nominated to replace Sandra Day O'Connor, I believe. And when he was nominated, Senator Schumer said that he was going to oppose Justice Roberts, but he wasn't going to oppose him simply because he was a Republican nominee. Why there were many Republicans he could support, and he then listed 3 or 4 people, of whom I was one, and those people had 2 things, as far as I could tell, 2 things in common. One is that they had been nominated by a Republican president, and the second is that they didn't stand a snowball's chance in hell of ever being nominated to the Supreme Court, or so I thought. In fact, the day after he did that, he did it, I believe, during a television program. I saw one of my former law clerks on the street, and he smiled at me and said, "Oh, I see Senator Schumer gave you the kiss of death yesterday." So, meaning that, of course, any endorsement from him would likely not be met with enthusiasm in the White House at the time. So I'm not convinced that one was entirely heartfelt.
Well, I'd love to switch gears a little bit and talk about your time now as Attorney General. You were President George W. Bush's last Attorney General. What were some of the biggest issues that you faced at that time?
I think some of the biggest issues related to what had been regarded as the politicization of the department and the need to pull back from that. Many of the people who were involved in the episodes that led to the claims had left. But I think that there were lingering effects, and a lingering effect on the morale of the department. And I think the point was to get everybody back to doing what they did, which was to practice law. And that was what I tried to do. Soon after I got there, I tried to keep the profile of the department and my own profile low. We had a situation presented by the destruction of the tapes of interrogations by the CIA, and the question was what to do about it. And I appointed John Durham to do an investigation into that, and he later came to the conclusion that there were no charges to be brought. That was one of many assignments that he's had. Of course, he has one now that's sensitive as well, and I think he will do a superb job just as he did there.
When you were Attorney General,
Did you find that your experience as a judge affected your work there? Was it a benefit to how you approached that second position?
It was. It was of I would say of marginal use. It helps, obviously. It helps analyze issues, and so I brought that to the job. But it's obviously very different. You're part of the executive, not part of the judiciary, and so there's not a whole lot of overlay. I had been chief judge when I was in the Southern District, and that had some administrative responsibilities, but that's no preparation for the administrative responsibilities that go with being Attorney General. You're running an organization that's got well over 100,000 people in it.
Now, one of the issues that's currently swirling around in the media and Congress at the moment is FISA courts. We've seen that the FISA process was abused. There are calls for reform. Do you have any thoughts on this debate?
I have some thoughts on it. I think that the calls for some of the calls for changes in FISA are totally unwarranted and really unwise. We can't go back to a pre-9/11 approach to intelligence gathering. I have some skepticism about the FISA court generally. You recall it was an outgrowth of abuses under the Nixon administration, and the thought was to have judges oversee electronic surveillance, but judges have no special training in intelligence gathering. They don't bring a body of knowledge, and the idea was to get judges to approve applications. Obviously, they were relying principally on what they were told by the government. That's not to say that they rubber stamp these applications. They don't. I had personal experience with that. They review them very, very vigorously, and there's a back and forth frequently that people rarely hear about, in which this or that application is felt to be inadequate and has to go back to be supplemented. But my own view is that to have the executive applying to the judicial branch in a proceeding that is not in any real sense judicial for approval to conduct electronic surveillance is kind of a mismatch of talents.
Would you say that the current system, the executive going to the judiciary, is sort of the best that we could create? Do you have an idea for improvements? The system used to operate on the assumption that gathering intelligence, as opposed to gathering evidence for criminal investigations, was entirely the business of the executive, and that the executive would conduct that activity, and with its success or failure in protecting the country would rise or fall politically. I guess those days are gone, but I think that we have to. There has to be in place a vigorous system to permit the gathering of intelligence. Part of the problem that I think we've encountered is that it relies ultimately on having good, sound people. Mm-hmm. And there's no such thing as a system that will run if you have people who are not sound. In any system is subject to abuse. I think we're in the United States. We're very much taken with the idea of mechanical solutions. You know, we have a government that has a balance of responsibilities among legislative, executive, and judicial, and there are various mechanical solutions to problems. And we have a fascination with creating mechanical solutions to all kinds of problems, and sometimes it just doesn't work. And it doesn't work if you don't have honest people in place, particularly at the top. Well, with the last few minutes we have left, I'd love to ask you just a few parting questions. Of the various legal hats you've worn, do you have a favorite? Oh,
the favorite, the one that I wanted to do for
for the longest time was to be a judge, and I enjoyed that tremendously while I did it. Becoming Attorney General was something that sort of happened to me, like measles.
And if you could go back in time and change anything about your career, would you?
I've never thought about that, and I saw that on the list of questions, and I don't think that I would. I don't do retrospective analysis of my own career, and I don't do highlight films. There were performances in court that I would just as soon change if I could change them, but that's not really fundamental. I mean, that's just the fact that I made mistakes, and I learned from them, and so I guess they were useful.
And the question we ask all our guests on this show: if you could have a conversation with any Supreme Court justice, living or dead, who would it be, and what would you talk about?
Oh, I think without doubt it would be Robert Jackson, because of the clarity of his writing and his thinking and his understanding of the powers and the limits of the powers of judges and the function of a constitutional system. And I would want to talk to him about the current situation in which we find ourselves, and see if he could figure any way out for the courts in particular, in the nature of the questions they deal with and how they deal with them. I would love to hear him on that subject.
Interesting. Well, Judge Mukasey, thanks so much for joining us.
Thank you again.
So, Amy, I think that settles it. I win our debate about what you call an attorney general.
I think if Judge Mukasey has anything to say about it, you certainly win. I also think on Twitter, looking back at our poll, the clear runner-up was actually for Grand Legal Poobah, and my vote is for Grand Legal Poobah.
Mine too.
That is definitely how we should refer to attorneys general from now on.
Excellent. I'm with you.
All right, so moving on to trivia. Today it is my turn to try to stump GianCarlo.
I am so ready for this.
You certainly sound ready. So you ready to hear your theme for this trivia?
Hit me with it.
Earlier this month, we celebrated the 76th anniversary of D-Day, the Allied invasion of Normandy. So our theme for GianCarlo today is, drumroll please, World War II.
Oh, yes, I am so in this.
All right, we've got a couple questions. First one, I believe in you. We'll go with a warm-up question. You ready?
Yes.
Which infamous Supreme Court case upholding the forcible detention of over 100,000 Japanese Americans during World War II was only just explicitly disavowed by the Supreme Court in 2018? Bonus points if you can tell me which 2018 case disavowed it.
Oh, I am so on this. I got this. The case is Korematsu versus United States. And in dictum, in Trump v. Hawaii, Chief Justice John Roberts, writing for the majority, disavowed it.
At this point, I almost want you to quote verbatim what it said. But okay, you nailed it. That was correct. It's Korematsu v. United States. And in the 2018 case of Trump v. Hawaii, the court wrote, quote, Korematsu was gravely wrong the day it was decided, has been overruled in the court of history, and, to be clear, has no place in law under the Constitution. So you're not actually 2 for 1 because you got the bonus points on that one. Heading into question 2, up 1. Which future Supreme Court justice, then serving as California Attorney General, was a leading proponent of the detention of Japanese Americans during World War II?
Oh, man. I feel like this is probably Earl Warren.
You said it as a question, but you got it correct as a statement.
Yes.
So it was soon-to-be Chief Justice Earl Warren. As California Attorney General, Warren referred to the presence of Japanese Americans in that state as, quote, the Achilles heel of the entire civilian defense program. He later came to regret his role in the internment program, writing in his memoirs that, quote, it was not in keeping with our American concept of freedom and the rights of citizens, and that when he thought about the innocent children being torn from their homes, he was conscience-stricken. So you are now 3 for 2 with your bonus question.
Oh, yes. I gotta be honest. I was pretty worried about doing trivia, so I'm feeling good.
Doing good. Doing good. Batting over 1,000, which is weird. That's weird to comprehend the stats there. Question number 3. Which Supreme Court justice worked as a code breaker during World War II?
Oh, I know this. This is John Paul Stevens.
It is. Stevens was recruited into naval intelligence by his college dean, who had himself been a code breaker during World War I.
Oh,
Now,
actually, I have another fun fact about this.
Oh, do tell.
John Paul Stevens' work as a code breaker, he was involved in Operation Vengeance, which saw Americans find and shoot down Admiral Yamamoto's airplane.
You just stole my thunder. You stole my thunder for the rest of these facts. There, I will point out, some have taken issue with the term code breaker. It is a bit of a misnomer. It turns out the Japanese radio code had been broken before the war, and so Stevens' really top secret role was actually applying the broken code to unravel intercepted radio signals. And he did have a very important role, as you said, in some very important parts of World War II, and he was actually awarded a Bronze Star for that work. John Paul Stevens was not the only justice to have served his country during World War II. Which other future justice served in the Navy as an intelligence officer, also in the Pacific Theater?
Oh, man. I'm going to need a hint.
So the only hint I have is that this is a justice we have talked about before in trivia, who he left to serve after he had had a very successful college athletics career.
Oh, man, I asked you about this guy 2
You
weeks
did.
ago. And now I've forgotten my own question. Ah, boy, this is embarrassing. What's the answer?
It is Byron White.
Oh, yeah. Byron White.
White initially wanted to join the Marines, but was prevented from doing so because he was colorblind. He was awarded not 1, but 2 Bronze Stars and, believe it or not, wrote the intelligence report about the sinking of future President John F. Kennedy's PT-109.
Wow, that's fascinating.
So you missed the last one, but because you got the bonus on the first, you still went 4 for 4.
Ah, sweet.
Good work. Well, folks, with that stunning performance by GianCarlo, that is our show. Thank you so much for listening to SCOTUS 101. Be sure to subscribe on Spotify, iTunes, or wherever else you listen to your podcasts. And please, please, please leave us a 5-star rating.
You can follow us on Twitter and Instagram at SCOTUS101 and email us at SCOTUS101@heritage.org with your questions, comments, or ideas for future shows.
Case is submitted.
You've been listening to SCOTUS 101, brought to you by more than 500,000 members of the Heritage Foundation. Executive produced by Amy Swear and GianCarlo Canaparo. Sound design by Lauren Evans, Valia Rampersad, Mark Guiney, and John Popp. For more information, visit heritage.org.